Can the police search your private property or premises without a search warrant? Let me say from the beginning that there is no right to enter a person's private property, and this was codified in our Constitution. Before this, the common law position was that there is no right to an arbitrary search. Now, Article 143(1) of our Constitution solidified this, and the Constitution is the most supreme law of the land. 143(1) says, to be specific, except with his own consent, no person shall be subjected to the search of his premises or of his property or the entry by others on his premises. However, it is important to note that this is not an absolute rule. There are some exceptions to this general rule. First of all, as we know, a person could come into your property, police specifically, with a search warrant. Outside of that, there is the common law position that a police could come onto your property if they believe somebody has committed or is committing a crime and they are there on your property. However, this is not an absolute position. There are exceptions to this general rule. Firstly, a police officer can come on your property and search it once they have a search warrant issued by a magistrate of the court. Outside of that, there is a common law exception which gives limited powers to police officers in limited circumstances to come onto your property to search. These include where someone would have committed or is committing a crime, or where they believe there is something there that is stolen or that has been used to commit a crime. Likewise, the Constitution itself in Article 143(2) made exceptions to the general rule. The main one of which is that where entry is reasonably required for the purpose of protecting the rights and freedoms of other persons. So clearly the exceptions to this rule surrounds where it is for the proper functioning of a democratic society. Now to look at vehicles, aircrafts, and vessels. Likewise, there is no right to search a person's private property because that is also private property. However, there are exceptions to this that are stated in Section 18 of the Police Act. 1. The police can search your vehicle if they believe that something that is stolen or something that was illegally acquired is in that vehicle. Secondly, if they believe and they must have reasonable suspicion that a person who has committed a crime is in that vehicle. Additionally, there is also the exception of where there is a person who may have in their possession something that is illegally acquired or stolen. For the police to search your property, meaning your premises or your vehicle, aircraft, or vessel, without a warrant and outside of those limited circumstances, such a search would be illegal. Now we should look at search warrants. A search warrant is issued by a magistrate giving specific instructions. When a police officer comes to your premises and they claim to have a search warrant, it is your right to see that warrant. You must read that warrant. A search warrant could be for a specific police officer, and only that person can execute it. Likewise, a magistrate could give authority to multiple officers or any constable to do a search warrant, but you must read that search warrant. A magistrate gives a search warrant after receiving certain information under oath, and she or he must be satisfied that there is enough grounds to issue such a warrant. These grounds include that there is anything connected to a summary offense which may be obtained during the search, anything which may give evidence of the commission of an offense, or anything that there is reasonable ground to believe caused or is intended to commit an offense. The police can also execute this search warrant on any day once given such permission by the magistrate. While traditionally, Sundays are not a day in which the police could receive and execute a search warrant, There are exceptions to this in the common law, as well in legislation, where the magistrate deems it necessary to give this warrant on a Sunday and have it executed on a Sunday, and the timing in which that warrant may be executed as well. A magistrate, in granting a search warrant, cannot only grant it based on personal information or personal facts given by a police officer. Those suspicions must be reasonable and not just something thought of by the police officer. Now, in executing a search warrant, firstly, as I would have mentioned earlier, when the police officer comes to your premises or they come to your vehicle, they must show you that search warrant. They must identify themselves as a police officer and highlight that they would like to execute a search using a warrant or with the authority of a search warrant. They must then allow you to read the warrant, and if they do not, you must request it. And so that all the information that is necessary is there as to who is executing this warrant, who issued the authority, and when it must be executed, and where. If it is at your house, they must rap at the door or rap or call at the gate, identify themselves, and then ask you to open for them. If they do not do this, that would also lead to an illegal search. Now, I must mention that should they rap at the door knowing that you're inside and you do not answer, they do have the right, under both common law and statute, to break down your door to execute the search. However, that action only comes after they would have attempted to have you open the door or giving you a chance to open that door. Now, after or during a search, the police may seize and retain certain articles. These are articles which they must be reasonable suspicion that would have been used to commit an offense or will be used to commit an offense. Likewise, there must be reasonable suspicion that it was stolen or unlawfully obtained. There are circumstances in which the police takes more things than they went there for, being that they might have a search warrant to search for, let's say, firearms or ammunition, and they find narcotics. The law makes provisions for that. It would not be legal if they find something else that should not be there, something that is illegal or unlawful on your premises or in your property. They can take it and use it as evidence in another matter. There are circumstances in which the police officers may obtain articles that are not or that were not unlawfully obtained or that were not stolen or were not used to commit an offense or will not be used to commit an offense. Said articles must be returned to the rightful owner within a reasonable time. If that is not done, you have the recourse of moving to the courts to have those things returned. Where a police officer or police officers execute a search without legal justification or without a search warrant, or which does not fall within the limited circumstances in which a search can be done without a warrant, such a search would be illegal. Yeah. However, you as a citizen who were subjected to an illegal search, whether or not something was obtained that can be used as evidence in court, have the right to move to the court for some form of remedy, whether you're suing for trespass or anything else of that sort. That is still open to you, whether or not something illegal was found on your property. Just to recap, there is no right of entry into a person's private property or premises. This was codified in the Constitution of Guyana. However, the police officers can search your property with the use of a search warrant issued by a magistrate of the court. When or if such a warrant is given to a police officer, they must present it to you to allow you to read that warrant. You must check to see if the correct officer is executing the warrant, if the correct date on which the warrant is to be executed is being done, the correct time, and likewise the purpose for which a search is being executed. If a search is illegally done on your property or in your premises, you still have the right to legal recourse, whether or not something illegal or stolen was found on your property. Audio Jungle.